October 1, 2020, alleged armed robbery of Gary Holloman. This police chase occurred on November 30th, 2021. The vehicle was not apprehended. The chase was ultimately called off. The identity of the driver on the day was never established, but even by preponderance of the evidence, which would be, I think, the standard for these evidentiary issues to come in. It was called off. There are no admissions, no photos, heavily dark tinted windows. So that's my position, Your Honor. I don't believe that this one would pass the muster, the requirements to meet the intrinsic acts threshold, and then after that, we believe that it's prejudicial and should be kept out on that as well. Because as the court knows, when we're talking about the 403 analysis, it talks about, it tells us and teaches us that we should not be allowing under 403 prejudicial items to come into trial that are scant.
Okay, I understand the arguments here from the state. And, I appreciate you bringing to my attention that the chase was over a year afterwards and the circumstances of that. And I know that in the state's filing from November 2023, they have the dates. So I'm not meaning to suggest that they were trying to pull anything over. We kind of ran through that real fast yesterday and, just kind of talked about a fleeing that was after the armed robbery that's an overt act. And I just kind of was thinking in my mind without looking at all of the words, oh, okay, this is at the same time. So thank you.
You're welcome, Judge.
Good afternoon, Your Honor. The state believes that this should be admitted as an intrinsic act. Just a few things for dates, Your Honor. So the preliminary hearing for the original armed robbery was actually in August of 2021. It was August 24th, 2021. At that point, the judge reserved her ruling and ruled either the next day or subsequently and dismissed the charges. Then in November of 2021 is when the state indicted the case. So November 8th, 2021 is when the case was indicted with additional charges, and the grand jury warrants were taken out on November 15th, 2021. This chase actually occurs on November 30th, 2021, so about 15 days after the grand jury warrants were issued in this case. And Your Honor, on November 30th, 2021, Investigator Flores was actually conducting surveillance on Mr. Huey. So the notion that the police or law enforcement did not know who Mr. Huey was, they did know who he was. They were conducting surveillance on him and watched him enter into the vehicle, so they knew who he was once he entered into the vehicle. They tried to initially blue light him and pull him over.
Was he driving? I mean, did they see him get into the driver's seat?
He was driving. He was the only person in the vehicle.
Uh-huh.
They attempted to blue light him and pull him over. At that point, he took off, and he, amongst other traffic offenses, went to the wrong side of traffic. They were then able to get the Phoenix air unit up to follow him. And the reason why the chase was called off, Your Honor, is because Mr. Huey drove in restricted airspace. So the Phoenix unit could no longer watch the vehicle because he was near the airport. Mm-hmm. And so they could not go any further, so they had to pull back and could not keep eyes on him. So that is why the chase was.
Okay. Well, let me ask you this. So, I mean, you have evidence that it was Huey who got into the vehicle and who was driving the vehicle, and that he fled when he was blue lighted. Do you have any evidence that he knew that the reason well, two questions. Was the reason they blue lighted him because they were about to arrest him on the grand jury warrant? And do you have evidence that he knew that, such that it would arguably be intrinsic to this charged armed robbery?
To answer question number one, yes, they were going to stop him based on the grand jury warrant. As to question number two, it appears, and I'm looking at text messages from his phone, and so I don't know. All I can do is quote what I have. And these are text messages from November 8th of 2021. He says, just wait till after Christmas and the New Year and turn yourself in and see what they're talking about.
All right, what? Okay, so, and the chase is November 30th, so this is several weeks before then.
Correct. And so the case went to grand jury on November 8th. The warrants were issued on November 15th. These are text messages he's receiving. And I want to make sure. Yes, it appears that these are text messages from his girlfriend to him on November 8th. And she's saying to him, just wait till after Christmas and the New Year and turn yourself in and see what they're talking about. She says it might not be a lot of time. You think somebody's snitching on you. And then his response is, I can't miss another Christmas, man. And then he goes, and yes, I don't want you to, but you can't run long either. That's going to make it worse. I'm lost. I don't know what to do. I would say to go to court, then they might lock you up. He's like, yeah, but then they might not. So it appears from text messages, he was aware that the grand jury at least was going to, had indicted the case. Again, warrants weren't out yet, but at least that the grand jury had indicted the case because those text messages are from November 8th of 2021. So that's the only evidence that I would have.
All right, well, I mean, given that he says, yeah, they might lock me up, maybe they won't, I don't think that, it's an argument to be made, but I think we're getting a little far afield of what's charged in this case. So I think I'm actually going to keep that particular incident out.
But I would just argue that he's fleeing from the armed robbery.
I know you're arguing that, but that's my ruling, so.
Thank you.
All right. All right, and with regard to the two kind of post-indictment intrinsic acts, or arguably intrinsic acts, the stabbing in the jail and the exchange of the Percocet. I've watched the video now about the Percocet. I mean, I think that the state's rendition of what occurred is, pretty much on point. I can't hear what any deputy says, but, I don't think that there was anything particularly off about how they described what happened. I mean, I see what happens on the video. I've looked at some further case law, and how soon do y'all need to know what my ruling is on that? Because I'm kind of having the same thoughts about if we're talking about, whether these actually meet any of the three requirements for intrinsic evidence, and then on top of that, 403, I'm just not real certain that these need to come in. I haven't made my final ruling yet, but I don't think that either of these is something that the state can't try the case without, which is not the only test, but I don't think they meet that test. So just kind of FYI on that. I'm having some.
Maybe we offer some case law to the court.
Sure.
We offer to the court in the circuit case decided June 20th, 2024, the United States versus Party, BJRBING. The site being 2024 U.S. app. Lexus 14995.
Okay, and what does it say?
Um,
Or if you've got a copy of it, that's fine too, or I can just plug it in here.
And Harding, we have a copy of it.
Okay.
And it's just standing for the proposition, generally the act that occurs after the indictment and.
Yeah, okay. Now, I've found my own cases that say that, yeah, that's clear. It's not, this indictment does not bar it from being an intrinsic act. That law is pretty clear.
Right, Judge, and if I may, just very briefly, let me stand up.
That's all right, I mean, I got it. It's just,
I guess going back to the court's question in regards to how soon we need an answer from you in regards to that. I can't speak for the state. I'm not sure when they planned to try and present that evidence, but I would ask the court to continue giving it its full analysis, especially in regards to the 403 and the overarching consideration as to whether or not they really need this particular piece of evidence to make out their case in chief. I don't believe that's the case, but I know that the court is wrestling with that. And I look at I don't know if I really need to look at the Harding case because we've already kind of established that issue is not really an issue.
Right.
But I'll be happy to look for some additional case law.
okay, thank you, I appreciate it.
Your Honor, you had asked the same. I'm sorry. Your Honor, you had asked the same of me. I have been pulling some case law, trying to put it together in a coherent presentation instead of just a list for Your Honor.
Okay, sure.
I definitely do want to take a look at this Harding case where it was found that the district court abused its discretion by admitting evidence as being intrinsic. So I certainly would like to take a look at that.
Okay,
So Your Honor, in terms of other cases that talk about intrinsic evidence, we would just cite the court to Jennings versus the state, 318 Georgia, 579. And I am just giving a list right now that for the court's consideration. This is not something that we have to decide right now. This particular one is not coming up at all soon. The next case is Anderson versus the state, which is 313 Georgia, 178.
and what are these standing for?
These are all regarding the intrinsic evidence and how it is that one is, how one is to look at and determine whether evidence is intrinsic, broadly speaking.
Okay. Yeah, actually, USB Harding, I'm pulling up what I put in my Lexis research folder this morning, and that's actually one of the cases that I was looking at this morning.
And the last one is Hughes versus the state, 312 Georgia, 149. And we too will present to the court a more coherent sort of overall arching.
All right, appreciate it.
All right.
Okay. So where do we want to turn now? What are y'all ready to talk about?
To the court. Like we have reviewed we haven't discussed it with Mr. Williams' counsel, but we've reviewed and looked over the Bruton motion redaction. Okay. So I'll let counsel for defendant Williams speak to them because this is Mr. Kendrick's statement that is already in. There are portions that he is arguing are inadmissible because of Bruton. Mm-hmm. Our position overall is that Bruton specifically requires that that a defendant be directly inculpated, and at these various points, I'll let them explain how they feel like someone is directly inculpated so that I can respond, but we've reviewed them and whenever the courts.
All right, so is it the state's position then that none of the identified portions of Mr. Kendrick's statement actually qualify under Bruton?
No, there's one enumerated time area.
Okay. Which one is that?
And they have it enumerated as
And has anybody sent me that statement? I think I asked, but I'm not sure that I received it.
Mr. Kendrick's statement?
Yeah, that's the one at issue right now. Yes. And maybe you did. Obviously,
We'll make
I'm
sure.
getting lots of emails through Ms. Percifield from all of y'all, but I don't recall seeing it. Maybe somebody could just send it now, since that's what we'll be discussing. All right, so which is the one that you don't have an issue with?
It's the point at which the detectives ask Mr. Kendrick, who do you think did it? And
Okay, so he's actually broken them down into little Roman numerals. So which Roman numeral are we talking about?
I wrote at the bottom my own timestamp. It's at 10004, so that would be. Here it is. It's their number 8. Well, they're number 9 really, but they're number 8 specifically.
Detective Gaither mentions Mr. Stillwell, the one that is labeled that.
Right.
Okay.
Well, it's labeled, I'm sorry, Mr. Kendrick mentions Mr.
Okay.
Stillwell telling detectives who they say
All right,
killed.
that's 8. Okay. And you agree that that should be excised?
Partially because what happens is that, this is the part that we would ask, that we specifically would argue, is not inculpating anyone. What Mr. Kendrick says is, they say, our crew.
Uh-huh.
And he's, in saying our crew, he's acknowledging that there is a crew. He said, because we're the ones beefing. And then they specifically say, who within your crew?
Uh-huh.
And at some point, Mr. Kendrick says, they say Shannon. That part, we would agree, comes out, but they didn't enumerate it exactly that way on this sheet of paper. So they say Shannon, we would agree, comes out. He then says, they also say Woody, and then they say Shannon and Woody. So the part where he's naming people that they say did it beyond our crew, or people that Mr. Kendrick identifies as his crew, or, in acknowledging that there's a crew, we would argue that part, we would agree, concede, that part definitely comes out.
Okay, so you're saying that they say our crew isn't Bruton, but when it goes further to say, they say, whoever the they is, but they say Shannon, they say Woody, that part you agree?
Yes,
Can
I
be
would say
redacted.
that specifically Shannon.
Shannon.
Yes.
Okay. All right, and every other one we're going to need to look at.
And, yes, I believe we should.
Okay.
The rest of them.
And has anybody come up with any case law about kind of the interplay between Bruton and a Rico or gang kind of charge? Okay. Okay, that's fine, as long as you're getting me something. They're two separate, well, not entirely separate, but I think we can do this without knowing the answer to that. Uh-huh.
If the state, if I heard correctly, if the state is not, over objection by the way, intending to play the actual recording, then it's just question and answer. So I assume they're going to advise the witness, whomever the witness is, don't mention Mr. Williams, or if you're going to mention Mr. Williams, what are the specifics? Because otherwise we're just going through something that they may not answer the question.
Your Honor, if I may respond to that, I'm glad Mr. Steele brought that up, because as we were going through these last night, there are portions that I needed to bring to the court's attention that I need the jury to hear Mr. Kendrick say. So we don't intend to play the video. Right.
Okay.
But there are portions that we would be introducing to have so that the jury hears him. And
Okay.
generally speaking, the overall method of introducing the majority of his statements would be through questions to avoid any implication of
Okay.
Bruton.
All right, well, if there are particular portions that you intend to actually have the jury watch and listen to, if you can let the defense know which those are, that would probably be helpful. Yeah, sure. So just let them know which of the portions, but okay, let's go through all of these if we need to, which it sounds like we need to. So do you want me to be, is there a transcript for this statement, or do I need to be listening to the audio?
We don't have a transcript of this statement.
Okay.
But we can. Since the defense has timestamps on it that are different than what we have, I think they may have downloaded it into an MP4 format, so it may be easier for them to play it from their format because I have a specific time.
Okay, sure. Mr. Steele, would you be able to play the video or the portions of the video that you want to litigate for us here so that I can know exactly what that says? Okay, that'd be great. Okay.
Yeah.
Sure.
Can I just bring up another concern on this
Uh-huh.
subject? The concerns aren't limited to Bruton. I still, we're talking about playing a tape where Mr. Kendrick says that other people are saying, he's not saying anything that he knows, he's not telling on anyone, but he's saying other people are saying that our crew and Shannon and Woody, and they're talking about taking Shannon's name out of it, which of course I'm in favor of, but I'm not even...
Yeah, no, I agree. That's a little weird that the state's evidence would be, well, I mean, here's what the rumor on the street is.
Right.
So I bet Ms. Rowland's going to say we're not intending to elicit that.
Exactly, Judge. The point is not, and we can tailor the questioning and the presentation of evidence to, not include.
Okay, well, I mean, I suspect the reason they're asking that now is because when we just went over that example, you thought that the only, and you may have just been saying the only part that I believe is Bruton is this part where somebody is specifically mentioned, and that's fair. But if you don't intend to use any of that portion of the tape anyway, or get a question and answer that would elicit that information, then it would be helpful if you would say that, because there's no point in us, spending time on something that the state doesn't intend to use anyway.
So to speak to that example, for instance, I might ask the detective a question that, did you talk to Mr. Kendrick about the Donovan Thomas murder?
Okay, that answer would be yes.
Yes. Did generally speaking, what?
Let me ask you this. Do you think that it's relevant for the jury to hear that, Mr. Kendrick said, well, here's what the story on the street is right now?
No, that part I don't. I don't think that part about, people on the street think X, Y, Z is relevant. The relevant part is his acknowledgement that
Our crew
is beefing with them.
Okay.
There was a us and a them that was in conflict.
Okay, so then the only part of that, then, that you might elicit is that he acknowledged that at the time this all occurred, his crew was beefing with the other crew.
Yes.
Okay.
Thank you for actually.
All right, so when we're going through any of these other ones, if there's something similar, just kind of let us know that, okay?
And And Judge, we've just now sent to the court, we're sending to the court the October 6, 2015 interview. Does the court need the evidence review player sent to it again?
So, no, I don't think so, but if we're gonna go by Mr. Steele's, playing of it that has his timestamps, I guess I'll just watch that on Zoom. Are we close, Mr. Steele? Okay. Okay.
And I don't want to belabor unnecessary points.
Mhm.
We are looking at it, and I was looking at this for the purpose of Bruton.
Right. Sure. Any other little discrete items we can deal with while we're waiting? No.
We could look at the operation plan, or that might be too long.
I mean, we're certainly gonna have to do that. I guess we can get started on that. Unless we're really close. 1 minute away. All right, we'll just hold for a minute. Or so. Or so. Come on, Mr. Cocoa. No pressure. Mr. Steele, how'd your oral argument go this morning?
The argument was good, but, you know, no one remembers the argument, so we'll see what the opinion is.
Okay. Yeah, sure. I mean, might as well fill our time some way.
So, it's in this courthouse. It says indictment on the cover. Second page has, typical indictment things, ways formal reading, etc. Third page has the grand jurors in Fulton County names. In count 1 through count 6, former district attorney Paul Howard does hereby charge the appellee with murder. Goes like that. So I didn't try the case, I did the appeal. The Honorable Judge Newkirk granted the motion for retrial, finding no jurisdiction because it was an accusation. So the Supreme Court was very liable.
Interesting.
It was an interesting case, and then it got so narrow. I was being asked, well, this is a novel issue, how would a lawyer know, you're saying it's deficient performance, how would a lawyer know? And I'm like, well, if I know, then anybody could know, because I'm not that deep, so
Yeah.
that's what I said. But it was fascinating, it was interesting.
Interesting.
And thank you for letting me attend.
Absolutely.
So, Your Honor, this should have.
Okay. We spent all that time on the wrong interview. All right, well, maybe we can turn to the PowerPoint issue and at least start making our way through that, unless, are we ready now on the right one? Okay. So we want October 6th, is that right?
Yes.
Okay. Lawyers and tech, they just don't mix.
I hate to defend Mr. Kokomo here, but this is a lawyer issue, not a AV issue at this point.
Okay. So Ms. Love, I know you said the state's timestamps were somewhat off, but can you get close? Maybe maybe we just go that way. since this seems to be taking longer than we had anticipated. The defense thinks they've got it and the state thinks they've got it. So the defense has got it. All right, let's do it. Yes.
Just to avoid the inevitable confusion, the numbers, the times that we are giving is based on the MP4 that was made from the evidence reviewer. So, and we can figure out how to convert that. But the 50 minutes, for instance, is not going to be 50 minutes on evidence review.
Okay. All right. Well, thankfully, we've got the kind of general subject matter listed as well, so that'll help us.
Do we want this more? I assume we have that more. So now we're on thumb drive.
What we're playing now?
Yeah, with case companies and appeal. Do you want to just know what we're looking at since we're saying 50 and we can do that?
Sure. Yeah, that's probably the easiest way to do it. So I guess this is the hearing on Mr. Williams' Bruton motion. Yeah.